Hello, this presentation will explain defamation and take a closer look at two landmark cases, New York Times versus Sullivan and Gertz versus Welch. Defamation is the legal term for statements that harm someone's reputation. If the statements are written or broadcast, the defamation is libel. If it is not written, it is slander. A plaintiff that is a private citizen must prove four things to show defamation. The statement must be published in some way. This includes blogs and cartoons as well as more traditional platforms. The statement must be verifiable and false. It may not be a false claim to say that someone is the biggest jerk on the planet, but it is not verifiable, so it is not defamation. Claims that are metaphorical, like dumb as a post, or hyperbolic, like the worst ever, are not defamatory comments. The statement must be injurious, must cause harm to the plaintiff's reputation. The statement must not be privileged speech. Examples of privileged speech include testimony in court cases and government proceedings. If the plaintiff is a public figure, such as a politician or a celebrity, actual malice must also be proven. Actual malice means the respondent knew the statement was false and harmful, but did not care. The case of New York Times versus Sullivan is an example of defamation involving a public figure. L.B. Sullivan was a Montgomery, Alabama commissioner in 1960. The New York Times ran an ad, "Heed Their Rising Voices." Although the ad never mentioned Commissioner Sullivan, he felt that it strongly implied his connection with several acts of civil unrest. The ad said that, quote, "After students sang 'My Country 'Tis of Thee' on the state capitol steps, their leaders were expelled from school and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. When the entire student body protested to state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission." End quote. It does not make a big difference in the events that the students actually sang the national anthem, not "My Country 'Tis of Thee." It does, however, make a difference that the 9 students that were expelled were not expelled because of a demonstration at the Capitol, but for demanding service at a lunch counter. The police were not called to the Capitol. The entire student body did not protest. Those that did staged a one-day class boycott. Students did not refuse to re-register, and the dining hall was never padlocked. Although the article never mentioned Sullivan by name, he felt that since his position of commissioner would have put him in charge of the police, people would associate him with the claims. He argued that he had been defamed by false allegations of police actions against students and against Martin Luther King, Jr. The ad claimed that, quote, "Again and again the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses, and now they have charged him with perjury, a felony under which they could imprison him for 10 years. End quote. Martin Luther King had only been arrested 4 times, not 7. 3 of those times were before Sullivan took office. The bombings also predated Sullivan's commission, and the police were in no way tied to the bombings. The New York Times did not bother to check any of the statements made in the ad. There was a letter claiming to be from trusted individuals supporting these statements, but all of the individuals in the letter denied having endorsed the ad in any way. It was New York Times' established practice to accept a letter as proof of authorization. They had reported on several of these stories in the past with correct facts. At the trial, the jury was instructed that because the statements were libelous per se, the law implies legal injury from the bare fact of publication itself and needs no separate evidence. Initially, Sullivan was awarded his full request of $500,000. The Supreme Court of Alabama upheld this verdict, but the United States Supreme Court held that the verdict failed to uphold the freedom of speech and freedom of the press as found in the First and 14th Amendments. As a libel action by a police official brought against those criticizing his official behavior, it is important to provide all possible safeguards against misuse of the law. The evidence in this case was found insufficient to support the original verdict. The judgment of the Supreme Court of Alabama was reversed. The case of Gertz v. Welch, Incorporated, is an example of defamation involving a private person. Elmer Gertz was an attorney hired by the family of a child that was killed by a police officer named Richard Nuzio. The family hired Gertz for a civil case against Nuzio. Courts ruled that his involvement with this civil case was not enough to make Gertz a public figure. Robert Welch, Incorporated, published a monthly magazine, American Opinion. In April of 1969, American Opinion featured an article called Frame Up, Richard Nuzio and the War on Police. This article claimed that the police officer had been framed as part of a communist campaign against the police. Gertz was named as a leader in this conspiracy and was called a communist fronter, a Marxist, and a member of several subversive groups. It further claimed that the attorney had an extensive criminal record. Gertz had no criminal record and played no part in Nuzio's original trial. He was not a communist or Marxist. The managing editor of American Opinion made no attempt at verifying these statements against Gertz. Gertz being linked with the Communist Party, and therefore un-American, would have made his personal and professional life very difficult. Point number 47 of the case findings states that, quote, Gertz testified to the severe mental distress, anxiety, and embarrassment which he suffered as a result of the article, end quote. It further held that, quote, several attorneys testified at trial that calling a lawyer a communist would be highly injurious to professional reputation, end quote. Being accused of having a criminal record would also harm a lawyer's practice. Welch could have avoided this situation by checking the fact behind any accusations. It is also a good practice to get a signed release from anyone directly involved with the story. Fact-checking is a time-consuming but very important part of media interactions. Florida defamation law is similar to the defamation laws of other states. The minimum requirements are that a false statement is published about the plaintiff to a third party and causes injury to the plaintiff. Florida's Supreme Court views civil servants, such as police officers, as public figures. One difference in Florida defamation law is in criminal libel. False statements about the chastity of a woman or statements that harm the reputation of a financial institution are considered a first-degree misdemeanor. As defense in defamation cases, Florida law accepts substantial truth, or that the idea of the statement is true, even if the details are not. Opinion and fair comment, under which something that is obviously an opinion is protected. Fair report privilege, where the person making the statement has relied upon official documents or statements and made the source clear and used the source accurately. Wire service defense, if the statement came from a respected news source. And neutral reportage privilege for reporting statements from one public figure about another. Both of these defamation cases came down to definitions and details. For instance, is the plaintiff considered a private person or a public figure? When Gertz was mistakenly held to the standards of a public figure by Robert Welch, Incorporated, he needed to prove actual malice. He was not a public figure, and at the retrial in 1982, Welch was awarded $400,000. It's important to know the laws and keep on the right side of any technicalities. As a public relations specialist, knowledge of defamation laws will be important. This knowledge will help me keep my clients from accidentally libeling or slandering anybody. Working understanding of defamation will also help me protect my clients' reputations and effectively handle any defamatory statements with as little damage to their good name as possible. I hope this has added to your understanding of defamation laws and the cases of New York Times versus Sullivan and Gert versus Welch. Thank you for listening.